Hi, my name is Eric Niederlehner, and you're watching the Bankruptcy video blog. I'd like you to check out our website, shouldifileforbankruptcy.com, or give us a call, 877-607-2228, if you're considering bankruptcy or have other debt questions or credit questions. Today we're going to talk about what happens to a discharged debt. When you file bankruptcy, the ultimate goal of filing bankruptcy is to receive the discharge from the bankruptcy court, which is a permanent injunction against your creditors from ever trying to collect on any debt that's listed in the bankruptcy and that's dischargeable, such as credit cards, medical bills, signature loans, those sorts of things are all discharged in a bankruptcy and no longer owed. But bankruptcy attorneys, myself included, we say erase your debt, get a fresh start, and use those types of terms, but a discharge in bankruptcy doesn't really make the debt go away. It just prevents the creditors from trying to collect on the debt. And so it doesn't eliminate or erase the debt, it just prevents the injunction prevents the creditors from trying to collect on your debt. However, a creditor may still have options after your debt's been discharged. If there is a co-debtor on the debt that you included in your bankruptcy, and that co-debtor hasn't filed bankruptcy him or herself, then that co-debtor becomes 100% liable in most cases for the discharged debt. And while the creditor cannot come after you, the person that filed bankruptcy, the creditor can go after the co-debtor for 100% of that debt. So there are options. Other options are if the debt was secured, like a car, the creditor can repossess the property after the bankruptcy, and they wouldn't be violating any bankruptcy rules or laws. So if you file bankruptcy, stop paying on your car, the creditor can either file for relief of the stay during the bankruptcy and repossess the car, or wait until after the bankruptcy is over with, or the automatic stay has dropped off after 45 days of the first scheduled creditors meeting. Then the creditor would be within their rights to come and repossess the vehicle or whatever other secured property that might be securing the loan. There's ways around that, and they include redemption, which means buy the vehicle or whatever the property is, buy it at fair market value, and that's negotiated between you and the creditor. And you pay a lump sum for whatever the value of it is. So if you owe $10,000 on your car, but your car is only worth $3,000, and you purchased it over 910 days prior to filing bankruptcy, you can negotiate buying the car for a lump sum of $3,000 and get out of paying the other $7,000 that was originally owed when you filed bankruptcy. Cram downs in a Chapter 13, cramming down the loan to the value of the vehicle. So in that case, if you had a $10,000 loan, the car's worth $3,000, you cram it down to $3,000, you pay that $3,000 out over the course of the Chapter 13 plan. Another common thing that most people do in a Chapter 7 is reaffirm a debt. And by reaffirming the debt, they agree to be responsible for that debt after the bankruptcy and continue making their payments, and just like they didn't file bankruptcy on that debt, and they're liable for it after the bankruptcy. So if they later default on that loan, the creditor can come back and repossess the vehicle if that's what the loan was about, and potentially sue the debtor for that default or deficiency between what's owed and what they sold the car at auction for typically. Now, many debts that are forgiven or charged off can be taxed against the debtor. So a lot of people that try to negotiate with their creditors without filing bankruptcy to pay off their debts may be in for a big tax shock come the end of the year, because if they have a $25,000 debt that they settle for $10,000, there's a good chance that the credit card company or whoever may 1099 them for that $15,000 difference, and they're going to have to pay taxes on that at the end of that year. However, there is an exception for people filing bankruptcy, and debts that are forgiven during a bankruptcy are not taxable income, and you won't be receiving those 1099s for all that debt that you discharge if you file a bankruptcy. So debts do exist after the discharge, and they don't go away. You can make voluntary payments if you wish. You can pay everybody back after your discharge. Just nobody that has a debt discharge can collect on that debt. They can't send you reminder notices to pay. They can't call you. They can't do anything if the debt's discharged, because they can't collect on the debt. And they could be sued for violation of the discharge if they did send you reminder notices or try to collect on the debt. By making voluntary payments, you're not going to revive the debt or suspend or negate the discharge. So you're not really, if you came into a good job and were able to make payments and you're like, well, I feel bad, I want to pay all these people back, you can pay them all back, but then if you lose the job, you don't owe it again. So the discharge still applies, and you can make as many or as little payments as you want to any discharged debts. And the creditor cannot try to collect on that debt or contact you about that debt. So again, I'm Eric Niederlehner, and you've been watching the Bankruptcy Video Blog. If you have any questions, please give us a call at 877-607-2228. And our website is shouldifileforbankruptcy.com. Thank you very much.